This leads our bulletin this hour. The Constitutional Court provided the full judgment behind its July order that refused direct access to the Mkhonto party, as well as former President Jacob Zuma's bid to invalidate President Cyril Ramaphosa's three related decisions. That is the decision to place Police Minister Senzo Mchunu on leave of absence, the subsequent appointment of Professor Feroz Kachalia, as well as the establishment of the Maphanga Commission. Now, the Apex Court in July stated that the matter did not fall within its exclusive jurisdiction. The party's recent attempt to revive the matter in the Gauteng High Court in Pretoria failed after the matter was struck from the roll for lack of urgency. Now, delivering the judgment, Justice Ramaka Matopo ruled that the applicants failed to follow proper legal procedures and that the attempt to gain direct access to the Apex Court lacked legal foundation. The decision now deals a blow to the Mkhonto party's efforts to challenge presidential powers through the judiciary.
The more important and complex the issue in the case, the more compelling the need for this court to be assisted by the views of another court. In the result, the application cannot succeed on either threshold. This is not a matter that falls within this court's exclusive jurisdiction under Section 1674E of the Constitution, nor is it one where the interests of justice favor direct access under Section 1676A of the Constitution. Accordingly, it is not competent for this court to opine on the merits of the applicant's challenge to the impugned decisions, and that issue must be left for the right time and at the appropriate forum should the applicants be so inclined. On the question of cost, I find that although the applicant's case for exclusive jurisdiction and direct access is unsuccessful, the constitutional questions they sought to raise were not entirely without merit. The jurisdictional claims, though sufficiently pleaded, are not so manifestly hopeless as to warrant costs. By-and-large protection is that warranted in the circumstances, and each party should bear their own cost.
Now, the ConCourt was indeed busy today. For more on the MKP case and another topical case, that's the court ruling that both parents, regardless of gender, sex, color or circumstances, will now be entitled to equal parental leave that they can share among themselves. We have SABC News senior reporter Canny Maphanga to delve deeper into these issues. Good afternoon, Canny. Thank you very much for joining us. So a very interesting day in court today. Let's start with the Mkhonto party case. Now, the reasons have finally been furnished around why exactly their matter was dismissed. Just share with us some of those aspects that led to the dismissal of their case.
Indeed. Good afternoon to you, Mfundo, and to the viewers at home. You may remember that the MK party and former President Zuma, in a rush on the 31st of July, just ahead of that appointment or subsequent appointment of Professor Kachalia, sought to challenge the president's three related decisions relating to the leave of absence afforded to the police minister, Senzo Mchunu, the appointment of Prof. Kachalia, and then, of course, the establishment of the Commission of Inquiry, which we now know as the Maphanga Commission, and has already begun its hearings probing the allegations that prompted the president to take these three related decisions. So they challenged it on the lawfulness of the president's exercise of his powers. And they did so by heading straight to the Constitutional Court for direct access, not going through our normal judicial structure, which is to start at the High Court to ventilate issues of such a complex nature. Now, due to the time frame that the Constitutional Court had, because the president had to make sure that by the end of the month that a police minister was in place while another was on a leave of absence, they gave out an order which denied or refused rather that direct access, and said that reasons would follow at a later date. Now, that's what brings us here today. And you're seeing that they dealt directly with the exclusive jurisdiction, that is Section 167 subsection 4E, which would apply in this particular context, and how exceptional circumstances are really needed for you to go straight to the Constitutional Court, because you have to avoid a scenario where you have the Constitutional Court, which is our highest court in the land, being your court of first and last instance in matters. You need to be able to ventilate these matters properly so that it can be considered appropriately if it were to go to the Constitutional Court. And in this instance, if they were able to deal with these constitutional issues that are being raised, such as how the president exercises constitutional powers, then the Constitutional Court, had it started at the High Court, would have been able to consider that matter according to that particular reference. However, because they made that their court of first and last instance, and they had a very broad approach on how they wanted to challenge the president's exercise of his legal powers, or what they alleged to be a failure to fulfill the constitutional obligations, they failed to engage that particular exclusive jurisdiction that you need in order to go to the Constitutional Court first. So the Constitutional Court made it very prudent that they're not going to deal with the merits of the matter, because they acknowledge that there are important constitutional issues being raised in this particular challenge or constitutional challenge brought by the MK.
No cost order that we heard there.
Yes, so BioWatch principle does apply because they are raising those constitutional issues. You can't hit them with costs just because they've lost this particular matter. So the option that it gives them now is that they can raise it in the High Court. Of course, the urgent matter failed because there was a lack of urgency, but they now have the reasons provided as to why they did not engage the exclusive jurisdiction of the court and how broad the issues were, and that, in fact, what they are raising may be more appropriate for review proceedings, which are in the High Courts, because essentially what you have is an issue of the president exercising his duties, or how he chose to exercise the constitutional powers afforded to him, not an issue of whether he failed to fulfill his constitutional obligation. Now, because of that, the court has stated, or rather made a point, that these are more appropriate for the review proceedings that is in the High Court. And then once you ventilated those complex issues through the High Court first, then you could possibly approach the Constitutional Court for confirmation if you're successful in constitutionally invalidating the exercise of that power afforded to
And I remember
the
quite vividly the respondents had emphasized that point, that if you go to the apex court as your court of first instance, you really deny the lower courts the opportunity to also opine on such weighty issues, because by the time then it eventually gets to the ConCourt, if that were to be the case, then at least you're refining the judgment and it assists here in jurisprudence or the development of just the law.
Yes, and it's also going to assist the Constitutional Court because they now have some kind of foundation or basis to understand how this matter was ventilated. But now when you try to approach it as your first court and your last court, because that is our highest court in the land, you rob that opportunity of this matter being fully ventilated within our judiciary before a constitutional assessment can be made by the Constitutional Court.
And then to another matter that has piqued the interest of many, the confirmation by the ConCourt of the invalidity of sections that deal with maternity and paternity in the BCEA. Just share with us exactly what was stated today around this specific matter.
Indeed, like most of the landmark cases that you see come out of the Constitutional Court, is that they have to correct a lot of legislation that fails to meet the constitutional demands of today. So that they found with parental leave that it unfairly discriminates on the basis of gender and almost marginalizes one parent as the one that is not the primary caregiver and assumes that the mother is the primary caregiver. So again, it's remedying that defect that you've seen from old practices where there were assumed gender roles and legislation was designed according to that. But now you have a situation where they have invalidated parts of that BCEA, and of course that means now fathers and mothers have an equal share to parental leave, which now stands at 4 months and 10 days. So how they break it up, I think our legal expert will be able to elaborate further on that, but also the limitation that was given towards, or rather extended towards, adoptive parents, where children above the age of 2 were not included. And there wasn't that environment to ensure that when parents adopt children, that they are given that period to nestle into that environment and spend some quality time with their children as well. That wasn't considered in the legislation, and the Constitutional Court also found that unconstitutional. So Parliament has, I think it's just about 24 months to remedy that defect, and then of course there's read-ins to accommodate the various families that want to be given an equal share of those first few moments with their birth child, or in the instance where you have adoptive parents, they're able to get that time to nestle their children into that environment before they have to return to work.
Canny, very interesting. Thank you very much for joining us. That is senior reporter Canny Maphanga there, sharing with us at least more insights pertaining to these two important judgments. Now,